Tomorrow. Yes, yes. Next week, subject to tomorrow, day after tomorrow, like that. We give memos. Yes. Give tomorrow, day after tomorrow. A large number of memos are there. It will be adjusted and it will be listed also. Okay. What is adjusted? Pick it up tomorrow. Oh, nothing else. You can even otherwise also you can challenge. Nothing will. Once the process of selection is started, that cannot be stopped. No, that's a settled principle. Tomorrow, sir, please. To give tomorrow. Yesterday's matter. Judgments are there. Okay. Give both. Yes. Yes. Tomorrow, day after tomorrow, subject to the number of memos it will be. That when it has to be listed? 9th of March, 29th. At the request made by the learner council appearing for the petitioner list on 9th. So it will be slow also. Slow today will be slow also. Post but along with post on very same. Wait. Another 12 minutes I will wait. 45. Next week, let us. No, nothing else. 16. We will accommodate and both. Then it will be easy. At the request made by the learner council appearing for the respondent. Next week on date. 9th. 46. At the request made by the learner council appearing for the respondent number 7. List next. List on no some other matters are there. Yes. Apart from list after 2 weeks.
Number 48 to 54. Then number 55 to 60. Serial number 31267.
66. Who are you appeared? 66 is not 14%. It is BH Devaraju. No, what is one? You want urgentment. When do you want? Not tomorrow, you can take it up next week. Any date, whatever says 66. At the request made by the respondent number 1 dash party in person, list on 10th. List on 10th. $50? For whom that you are appearing?
Serial number 38. Order.
Yes. 37th, 37th, madam. Told. Then a council appearing for the respondent seeks 2 weeks time to file statement of objections. Just after 2 weeks. Which one, sir? Tomorrow. Tomorrow. Yes. Tomorrow you can. Yes. 53 at the request. 53 at the request made by the Lana Council appearing for the respondent. List on 2 weeks for 20. 15. 27. Yes. But you are seeking that you are going to revive it. But you want to revive the matter again. But you want to revive the matter. That's what that memo cannot be accepted. Because you say that the panchayat is likely to for all these 6 matters. All the 6 matters. Third, my dear. Third. ಒಂದಕ್ಕೆ ಮಾತ್ರ ಇಲ್ಲ ಮೇಡಮ್ 0.6 from infractures 1.6 sorry 1.6 and a council appearing for the petitioner submitted that the petitioner has attained superannuation. Accordingly, prayer sought for in the writ petition has become infructuous. Accepting the said submission, writ petition is disposed of as having become infructuous. Next to C number 1 to 1.5. Comma. And a council heard the Lena council appearing for the parties. Comma. Madam so and so appearing for the petitioner submitted that the petitioners hearing have made an application seeking appointment with the respondent panchayat and same is pending consideration. Accordingly, the petitioner submitted that accepting the memo filed by the petitioner hearing, the petitions be disposed of. Preserving liberty as prayed for in the writ petition, as sought for in the memo filed by the petitioner, writ petitions are disposed of. Yes. ಇವತ್ತು ಸಿಗುತ್ತೆ ಬಿಡಿ. Very well. One give one copy now also. When a counsel applying for the petition submitted that petitioner will serve IA number 1 of 23 to the learner counsel representing the respondent today. List chapter. That is promotion. That mandamus cannot be. You have no legal right. That cannot be done. Mandamus in all the cases cannot be. You sir copy, let the other side will. 3 could be done. 3 could. 2 cannot be done. 3 it may be done. Third, 3 table. 3 nalli. Third, the learner counsel applying for the parties. The short question involved in this petition is with regard to consideration of the letter dated 1/2/2021 issued by the government to the Directorate of Awesome to the respondent number 3. Taking into consideration the grounds urged in the petition, the third respondent herein is directed to consider the letter dated 1/2/2021 issued by the first respondent herein in accordance with law within 8 weeks from the receipt of this law. With these observations, the petition is disposed. Yes. Yes. What is the memo actually? You read it. The last portion is a big memo. The third respondent has intent to grant a retrospective promotion to petition. Accepting the memo dated 13/2/2023, seeking the withdrawal of the petition with liberty to file fresh petition on the very same cause of action. The writ petition is disposed of. Yes. You are not in time. You are not in the time. Who appear for the KPC? Karnataka Power Corporation. I mean, who appears for the KPC? Yes, Mr. Government. Yes, Mr. Who appear for the KPC? Karnataka Power Corporation. No, they have. Who appears? Yes, sir. KPC here. Ajay. Ajay J. Accept notice for respondent. Yes. Registry is directed to delete the name of Shri Vivek BR for the respondent and print the name of Shri Ajay so and so for the respondent. This matter day after tomorrow. Yes, sir. Copy to the madam. Yes. Day after tomorrow. Yes. I think 6.1 you wanted to withdraw. Is put him 6.1 put him 6.1 alone. Yes, sir. Six point one ಅಲ್ಲಿ ಮೇಡಮ್ 6.1 ಅಲ್ಲಿ the petition number 3 has filed memo seeking withdrawal of the petition with regard to the petition number 3 on the ground that the petition number 3 had taken voluntary retirement from service on 20th June 2022. Accordingly, writ petition is dismissed as withdrawn with regard to petition number 3 is concerned. Yes, what about the first matter? Who appear Kumara KG? Who appear? Petition come this side. What is this matter actually? What is wrong with annexure A? Correct. How it could be? The interim order is there in the other petition. You implead there, get it vacated. No. You get it implead in that writ petition in which the interim order is granted. Vacating the interim order and pursue. Here you cannot see there is no. I think the endorsement issued by the respondent outcomes is correct. Maybe no, nothing. This is a very short told. Heard the Lana Council appealing for the parties. Having heard the Lana Minister, it is the case of the petitioner that the petitioner is working as a second division assistant with the respondent cooperative society, and the grievance of the petitioner that some of the employees have filed WP number 43508, 551 of 2012, questioning the seniority list dated 24/2/2012, and the said petition was disposed of with a direction to the respondent authorities to redo the seniority list, and thereafter, the respondent society has issued as a finalized the seniority list as per in terms of the order dated 27/11/2013 in WP number 45988-97 of 2013 in bracket annexure B. It is further stated in the petition that some of the employees have again approached this court in WP number 61842-52 of 2016, and this court by order dated 24/11/2016, granted an interim order, and the said petition is pending consideration before this. Having taken note of the aforementioned aspects, I do not find any illegality or infirmity in the endorsement dated 11/10/2021 within bracket annexure A issued by the respondent society. So if at all the petitioner is agreed by the action of the respondent society, it is open for the petitioner to implead in this above writ petition for vacation of the order if so advised. With this observation, writ petition is disposed of. What about 6.1? 1 remaining. What about the remaining 1, 2, and let it be taken up by anybody? 7. Petition number 3 ಮಾತ್ರ. Only petition. Where's past the order? So the appealable order. Whether it is an appealable order, annexure P, P and W, whether annexure W is a appealable order. Appeals Karnataka Education Appeals. Karnataka Education Act. Appeals something. Bill Revision and Review Rules 1998. This is for which school, sir? Then appeal from the order passed by the commissioner is Director of Public Instruction in the Office of the Commissioner. The Director Collegiate Education. No, let us wait. What is IA 2 of 22? IA 2 of 22, what is this? Sir, copy. Sir, copy to rectify the office objection. And a council appealing for the petition seeks 1 week's time to remove the office objection. In IA number 2 of 20. What is that? 2 of 20 posting. Told him. Heard the Lana Council appealing for the parties on IA 2 of 2022. Let's just matter next week calendar. Next week in B group on 9. Accordingly, IA 2 of 22 is disposed of. Yes. Huh? One.
Contractual. Purely contractual is terminating order as well. Petitioner as a manager in my company. However, please come to page number 4, paragraph number 10, madam. The cause of action is good.
But you are working as a probationary.
She's a manager working in my company.
Maybe, but you are on probation. You are on probation. It is the
Probation was completed, madam. Probation was well completed. She was then, she in fact admitted for the contract.
yes. What is the wrong with you? See, you are.
She admits that there was a particular contractual clause. In view of that contractual clause, that business clause, and given her 2 months
Correct.
she admits to say, it's a matter of time, and repetition is not maintainable in my humble service.
You are part
Responding.
from this way. I'm thought that you are for the pet. That's good. How it is it's correct actually. That's what I'm saying. That's what I mean. So Monday is a good day for you for order. No. Even otherwise, is a respondent is you have to approach the labor code for grievance. So Monday letter. One more opportunity. At the request made by the Lana Council appealing for the petition list on Monday. Which is the order impugns? Which is the order impugned in this application. Annex M. K and M. So comply with the office application. Now, even on interim period to be clearly stated and supported by annexures. 1 week's time is granted to comply with it. No. 1 week's time be granted to comply with the office objections. Next one. Show cause notice. What is the law on the point, sir? What is the law on the point for challenging the show cause notice? That may be your defense for the. That may be your defense for the.
That has been expressly excluded from the act. Any action taken allowed by the corporation because they have to abide by the corporation. Corporation has shown that the corporation has taken a decision or calling for tenders by the public tenders.
Yes, sir.
The KTP Act itself is not applicable to the case management.
KTTP is not applicable.
No, that has been expressly excluded. Section 4 of the Act.
Let us see. You comply with the office application to be taken up. Any other? When a counsel applying for the petition seeks time to comply with the office application. Complaint moves. Comply with the office application. Yes. This next week.
My lord, I appear for the petitioner. In this case, my lord, I'm only
Delay maybe.
169 days delay.
Delay of 169 days in filing a review petition is condoned, accepting the cause shown in the affidavit accompanying the application in IA 1 of 2022. IA 1 of 22 is allowed. Let's just matter for admission next week. 2 weeks time to take. 2 weeks time is granted to take necessary steps insofar as unserved respondents and to comply with and unserved respondents. Yes. What is your prayer, sir? Three weeks. 3 weeks. Sorry, Mr. So and so. Yes, Mr. So and so, Lana counsel applying for the petitioner submitted that he has entered appearance on behalf of the petitioner by filing power. Registry is directed to print the name of Mr. So and so and delete the name of Sri M. Raghavendra Achar appearing for the petitioner from the card list. Next week. List next week. Next. Let us will take it up. IA 1 will stop. IA 1 of 23 is allowed, except in the cost shown in the affidavit accompanying the application. There's just matter of 2 weeks. In 2 weeks in B group. Yes. 2 weeks per term. Yes. 15th. 15th is the EAT order is questioned. To be taken up. What is the urgency? Nothing. Huh? No, what is the urgency? I know EAT order is questioned. The stay is granted. What is the stay granted? Actually? Huh? What is the stay granted? So respondent institution is hereby directed to reinstate with a 50% back notice. Whether the interim order is granted? Interim order is granted. Interim order is granted, sir. You have you reinstated it? But you have to pay him. At least. No, that's a different. First, we go to the facts, formal judgment. First, we go to the facts of the case. Either you have to reinstate him or you have to pay the back pages. There should not be, staying the entire order as such. Get ready by day after tomorrow. Huh? IA 1022 filed by the respondent is respondent number 1 is accepted. Accepted. Is this matter in B group day after tomorrow? Day after tomorrow too. Let us will see. Day after tomorrow. For promotion, it may be taken up later. Lana counsel appealing for the respondent seeks 2 weeks time to file. No. It's a promotion. It seeks 2 weeks time to file statement of objections. No. List after 2 weeks. Let us will see. List after 2 weeks. But they have to file the statement of objection. But they will file a statement of objection.
People or interim order. You are not kindly have a look at the order dated interim order after the
Yes, sir.
7th of July 2020.
Yes, I've seen it.
That order.
Yes.
As of now, my only request is whatever I'm just saying, let's first get educated from QC to state.
No, this is so the government shall file the extension of UGCs. They will file a statement of objection.
They are filed. So,
They have filed.
yes, my only request is this court take that order. Plus, after that, this court directed to pay the state share. After that, they are reduced into this credit, which is not that is recovery state, consequently, of course, we will. So on that premise, no sensitive.
Correct. Undisputed that you can. Anyway, now you say that now need very well. Now today is AGA saying.
What is this undisputed? Please tell us.
Yes.
Otherwise, there is no undisputed. Only undisputed is my
So
last.
that pension is to be calculated in terms of observation made also and set to the pension actually within a period not later 3 months from today. However, made clear this order is part without prejudice. Anyway, now they have taken actions.
The quality education board has started to.
So
This is the condition.
when you are going to this one? By Monday you will get. By Monday you must see to that some amount will be deposited. Either you have to satisfy the order dated 7/7/22,
Or the original.
or you have to. No, first matter only. No, this is no. This is an order dated 7/7/2020. That you are bound by that. So not not recently. So last July this order is passed. Then by Monday you have to file an affidavit regarding this. Yes. No. Letter will be written every day, but complaints is required. Who has to file? Who has to take decision in the matter? Let collegiate education. Respondent number.
The director of quality. Page number
19. So cost type to start from page number 19.
Sorry, because of these.
I am saying that cost type to start from page 19. Synopsis about 18 pages. Very good. First of this code by order dated 7/7/2022 directed the respondent government to calculate the pension and to settle the same within a period of 3 months from the said date. Then a council appealing for the petitioner submitted that the respondents have not complied with the order dated 7/7/2022. Accordingly, the third respondent herein shall file an affidavit for having not complied with the order dated 7/7/2022 by Monday date, by Monday. Or else, last July this order is passed. By Monday, you file an affidavit. It has to be listed tomorrow. Not letter. Complaints of this order. It's passed in July, last July, and you are not complied with. Otherwise, Friday, that is third. Let it will go. It is up to you. For me, I want that this order should be complied. Yes. 6th, list on 6th. Yes. 18, sir. 18, sir. No, let us list. Some other matters are there. 230. Rectification statement of your third copy. Lana Council appealing for the respondent number 3 and 4 submitted that the copy of the statement of objection is served to the as filed the affidavit to the Lana Council representing the petitioner. List this matter next week. Let us some other matters are there. 230 bare matters. Next week let us.
Before your state.
List on 7. List, no, reserve arguments. Arguments are reserved. Who has to consider? We can consider and take a decision in the matter. Yes. Heard the Lana Council. Heard the Lana Council looking for it. The grievance of the petitioner is that the petitions have approached the respondent authorities seeking redressal of their grievance with regard to take steps for promotion and other consequential benefits as per the representation dated. Just 1 minute, 1. As per the where you stated representation. Along with the representation dated 14/2/2022 within bracket annexure H and 18/3/2022 within bracket annexure J to the Recruitment. Having taken note of the contents in the representation, the respondent BBMP is directed to consider the said aforementioned representation in accordance with law. It's made clear that this court has not expressed any opinion on the merits of the cases. Consideration of the representation be made within 8 weeks from the receipt of this order. 8 weeks from the receipt of this order. Submitted. I've seen seal is there. Seal is there actually. Within 8 weeks from the receipt of this. Yes, Mr. R1 and R2 has to consider. The only thing is they have issued a legal notice. Third, the Lana Council appealing for the parties. Grievance of the petitioner is with regard to the consideration of the letter dated 34/2019, 8/8/2019, and the legal notice dated 20/11/2021, within bracket annexure B to D respectively. Having taken note of the contents in the aforementioned letter is, as the petitioners hearing are seeking the gratuity seeking gratuity which has been enhanced subsequent to the amendment made to the provisions therein. I am of the view that the first and second respondent are directed to consider the aforementioned petition within 8 weeks from the receipt of this order. Yes, accordingly, the petition is disposed. Yes. Which before? ಅಲ್ಲಿ ಧಾರವಾಡದಲ್ಲಿ ಇದೆ ಇಲ್ಲೇ ಇದೆ ಇಲ್ಲೇ ಇದೆ ತಗೊಳ್ಳಿ discovered by order dated 24/2/2023 adjourn the matter today for further hearing. That way of the matter, registry is directed to post this matter before Honorable BMSPJ for further hearing. Date non-product. You move it, it will be done. Yes. Non-compliance, but you have to comply with certain 1 week's time is granted to comply with the office objection. Interim order granted earlier extended till next.
2 weeks.
Yes. Then a council appearing for the R8 alone. Then a council appearing for response number 8 seeks 2 weeks time to file statement of objection. Interim order granted earlier extended till next. No, no. No, nothing else. Let us will. Okay. Whether the pleadings are completed? Pleadings are completed. All of you have filed statement of objection. It may be taken up next week. B group. Any day of your choice. Next week. When a council appearing for the party submitted the pleadings are completed and the matter requires to be heard. Accordingly, IA 7 of 22 filed by the file is 7 of 22 is allowed. This matter is a final hearing or B group. This matter in B group on Monday next week. 8th or 9th. 9th you can get it in B. That's it. EAT order is question. Or vacating order. Right? Only thing is it has to be heard. It's a 22 matter. Correct. What is IA number 2 in before EAT? What is IA number 2, sir? Before, because page 173 says that the IA is allowed by the trial court. Actually. Just 1 minute. Because what is challenge is no, that is IA number 2. Please kindly see the prayer. Issue a writ of certiorari quashing the order so and so on IA number 2. You are not seeing the prayer also. This is the prayer actually. If it is IA on pass on IA, then what is the final order then? Just go to impugned. Just go to page 173. Last page in the IA number 2 filed under so and so by the appellant is hereby allowed. What is IA? Whether the final. But had he challenged the final order? Still pending. You see against interim order. Main matter is still pending consideration pursuant to the remand made by this court in WP 5988. So anyway, the matter is pending before the tribunal and could be disposed of. Huh? Correct. That is that is a condition precedent. Yes, correct. Well, if you're ready, I can take it up later. Thank you. No, that's okay. There are counsel appealing for the petitioner seeks short accommodation. This matter on 21? 9 in could be taken up in B group so that list in B group. List in B group on 9. Yes. No, anyway, the earlier order is there. Yes. What your challenge? What your challenge? Sir? Annexure A, yes. Yes. What says that you did not have the requisite the qualification. Now, what is wrong with this order? According to them, now UGC so and so ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಹೊಂದಿಲ್ಲದಿರುವುದರಿಂದ ಅರ್ಥಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸ it cannot be considered. Nothing wrong in this order. Interim order ಏನಿಲ್ಲ ಅಲ್ಲ ಇದು. IA 123 is allowed and a council to list this matter in B group next week. Yes. That's what I think, because the parties are I think AW. 21 tomorrow day after two. But at the request made by the Lana Council appealing for the petition list day after tomorrow. Because the very same notification was challenged. Just go through it. Yes, very good. Earlier interim order granted earlier is extended till next October. Then a council appealing for the respond number 4 and 5. File memo dated 1/3/2023 enclosed the copy of the order dated 10th February 2023 in WP number 103170/2022 and same is accepted. Twenty-one 21 seal number 21 interim order granted earlier extended till next October. Is for repatriation. Huh? What is wrong with this order?
Yes. It expires after 5 years. What happens to the 30? It's not legally honest. Not just for the application. But it has got application, and that application unit is put there. This is a tax order.
Now, what is wrong with the impugned order of repatriation?
Yes. Let me see another Q.
Section 107. Yes, sir.
The Repatriation army says so. The regulation is so.
Yes, sir. Then what is wrong with this order?
Quite sure. Because it is a commentary from
But in Ministry of Home Affairs, you have no right to say that I have to stay here. One minute. Let you.
Purpose will come against me. The real matters is what he become in Canada. Because of the British was why suspended. After press. And when you use it now, and when you see a very hard of the department, possibly the PI one. There's no indication now. This is the
I will hear him. Yes. Yes. That is order dated 11/8/2018. Where is that? 25. While on deputation. That's what. As amended from time to time. (28). Yes, sir. Yes. An employee is appointed on deputation, foreign service, his services are placed parent ministry department at the end of the tenure. Yes. 32. 32. Yes. Intelligence Bureau. Yes. Yes, yes, surveyor. Save country. Don't think about wife. Save country. Yes, repatriation order is correct. Order passed by the Home Ministry is correct, sir. Yes, maybe. So that's a different. That's a different. Yes, yes, earlier. Think about country. Repatriation, dismiss, reasons to follow. That I will. No, no, no. No, so it could. No, no, no. Repatriation is dismissed. Huh? Oh. Yes, you have to go wherever they will post. No. Huh? No, no. Resolve your dispute with wife in a different aspect. First, think about country. Think about country being in a yes, yes. Now you are sandwiched between country and the wife. You are sandwiched. Opt for anyone, whatever. Opt whichever you like. That's all. Nothing else. No, no. Repatriation dismissed, reasons to follow. No, you have to, repatriation order is correct. They're given even 3 months time, that also in fact 1 month's time. Tomorrow you will get order copy, nothing else. No. You have to go here. You said you have to go from here to Delhi. You have to book ticket. No, that's why. No. You have to get. You have to get. No. You have to get ticket either railway or nothing. Yes, you are doing dangerous to the country. No. Reasons to follow. Repetition dismissed. No. No, nothing. It's next matter. Knowledge. You file copy application today. Tomorrow you will get. Nothing else. Nothing will happen. Lot of things. No. Nothing else. All the arguments are considered. I will hear you now if you want to. Today you have to. Bad. Mata kid list. You already have argued. Yes, reply. Next matter. Next matter. Just to follow this. No. 28. Yes, Mr. Vinigopal. Yes, Mr. No. Nothing else. Yes, then a friend will argue. No, nothing else. No. Today is a good day. We will argue. Argue. No. Tomorrow you will get the order copy. Argue. Subsistence element says. Yes, you have kept him under suspension and yes. Consideration is different, but consider within 2 weeks. No. So subsistent violation, you have kept him under suspension and not providing subsistence allowance. Told. Heard the Lana Council appealing for the parties. It is a grievance of the petitioner that the petitioner has been kept under suspension, and even after 6 months of passing the order of suspension, the respondent BDA has not paid the subsistence allowance to the petitioner. Accordingly, the petitioner has made a representation dated 22/8/2022, 19/10/22, and 2/11/2022 within bracket annexure H, K, and L respectively, close the bracket, taking into consideration the legal right urged by the petitioner, and the respondent BDA being an instrumentality of the authority under Article 12 of the Constitution of India, are directed to consider the aforementioned representation within 4 weeks from the receipt of this order. The outcome of the same be made known to the petitioner forthwith. Yes. Yes, sir. Notice. Salary and allowances. I will issue notice later. Issue notice to the other sides. Issue emergent notice to the respondent. In addition to this, petitioner in person is permitted to serve copy to the Lana panel council representing the respondent corporation. Yes, government. 38, sir.
Post of professor in urinary medicine. And both
Cardiothoracic, yes.
Annexure E,
Ah,
Annexure F, page 41. Page 41.
correct.
Assistant professor, 4 posts of cardiothoracic surgery and post of urinary medicine. Next, page 9. Which students were asked to appear for interview.
Yes.
But the merit list is prepared at Annexure H, page 41.
41, sir.
Yes.
Yes, sir.
For name and place. Now, Lord, Annexure J, page 52. But
Where is the selection list?
this is a provisional list, Annexure J.
Annexure J is a provision. Yes, correct.
Page 52, Lord.
So your name is so and so. Yes.
My name is not mentioned in the Annexure J.
Ah.
But against one post of urinary medicine, 2 persons are not selected. Though not
Notified is only one post.
2 posts who are
They appointed 2 posts.
selected.
Selected 2 posts. That cannot be.
But, against 4 posts of
Thoracic surgery.
then cannot be.
No. So for cardiothoracic, of
In
course,
excess of notified posts,
that cannot be done.
then they select.
This who has notified actually. So yes. No. Notification was issued for appointing only one candidate, but the respondent appointed 2 candidates. How it is possible? No, it is not instructions. It's a principle of law. Notified is 1 post. Appointing 2, selection list is passed, listing 2 persons. How it could be? Huh? When do you get it? When do you get the final? When do you get the final selection list? Monday. You get it by Monday. Let us will see. Selection list is told. Learned AG accept notice for respondent number 2. Full stop. MS Nagraj, Learned AGA submitted that he will get instructions with regard to the appointing 2 candidates under preliminary medicine in terms of the notification dated 23/12/2021 within bracket annexure E to the Repatriation list on Monday. That will see. No, that's a difference. Even otherwise, you can't appoint 2 candidates for 1 post. Tuesday, na? Tuesday, madam. Tuesday, list on Tuesday. Yes.
For 32?
Who has to consider? Government has to consider. Heard the Lana Council. Heard the Lana Council appearing for the part. Mail get it. Maybe. See, so for a pension and all those things, we cannot be apply. Ravindran Sahib on judgment to the 2006. Should we? Learned AG accept notice for respondent 1 to 3. Next, having heard the Lana Council appeal for the parties and taking into consideration the grievance raised by the petitioner for seeking DCRG, I'm of the opinion that the respondents herein are directed to consider the representation dated 1/10/2022 made by the petitioner within bracket annexure K to the repetition within 8 weeks from the receipt of this order. Result of the same be made known to the petitioner. Yes. Yes. Office note. Office. Yes. No notice.
Yeah, we are only considering that we are directly recruited. So only 7% now.
Yes.
The recruitment means we have not been thinking of the promotion in my group.
Take notice. Let us. Leonard AG. Leonard AG accept notice for respondent number 1. The Shri Nagaya panel council representing the second respondent society accepts notice for respondent number 2. Let us will see. After 2 weeks, that they will get instructions.
They give promotion by virtue of deputation. So transfer will
No, no. Let the second respondent sir copy and 2 weeks, next 2 weeks. 16th, yes. Who has to consider? Who has to consider? Who has to consider? First. Who appear for common cadre committee? You named someone so that we can. Better. Issue emergent notice. I know, I've seen. You serve, in the event if they serve copy and you can move it so that it could be discussed. Alexa, H. Same. 32 nal ಮಾಡಬಹುದು 32 ನಲ್ಲೇ ಸೇಮ್ ಇದು 35 ಕೂಡ consider annexure A ಅಲ್ಲ voluntary retirement in service annexure A within bracket annexure A consider same order. Yes. Disposed of Canada AG is accept notice for respondent, all the respondents disposed of. Annexure. L is the letter dated 7/3/2022.
Which is also passed. And actually, in that page,
49. Sir.
49. This is the directive issued by the respondent number 3 to the principal. 50.
Which petition, sir? 36.1. 36.1. 50. First matter or second matter? Second matter. Tamdu second matter.
1318.
1318 49 is different.
1318.
Page
49.
49.
49.
That is annexure N. That is the letter dated 19/2/21.
The letter is addressed to the principal of the college.
Yes, correct.
There are
Yes, correct.
What is the proof of appointment candidate is cancelled and therefore they are not.
So one thing, let they will get instructions. That they will file, but that they will file the statement of objections. That AGA seeks short accommodation to file statement of objection. List after 2 weeks. Let us see. List after 2 weeks. Let us see. 2 weeks. You can file thereafter. Huh. Where is the suspension order? Where is the order of suspension? Annexure C. Huh. Huh. So pending inquiry have been suspended. Yes. Now what your challenge is the order of suspension. Huh. What's wrong with that? That they will do it. That's why they said it. ತನಿಖೆಯನ್ನು ಕಾಯ್ದಿರಿಸಿ. Yes. I've seen it. Paid subsistence allowance once. See, order of suspension cannot be passed. Anyway, the pending inquiry. Yes. Departmental. That you will get this. That's the subsistence allowance. Only thing is whether they have initiated inquiry or not. In terms of Ajay Kumar Chaudhary's case, let us see. For all the respondent, see, A. Nagarajappa and a council submitted that he has been instructed to appear on behalf of all the respondents. Full stop. Then a council for the respondent seeks 1 week's time to get instructions into matter. This next week on date. This turn soon. By the time you can get it. Nine. Yes. Which order? Which annexure has to be? Annexure. Annexure K means annexure K is the statement of objection filed in the Repatriation. How can it be considered? We said K. Annexure N has to be considered. Just that is Director of Municipal Corporation. Yes. 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 Let you consider annexure N. Let you consider annexure N 2-23. Third, the Lana Council applying for the practice. Mailgada. No. Mailgada. Leonard EG accept notice for respond number 1 to 3. Yes, sir. Anyway, your grievance is yes. See, your prayer is with regard to annexure J. $63. Yes, sir. Yes. Sir. Yes.
Then go to body.
Ah,
Which about 50% is there. It's a very defined.
correct.
But as per the statement, this will be point number 4. Okay. If there are 28 for the subject for then it very defined.
Yes.
Information is
Yes, sir. Ah, permanent.
So that you are the permanent employee. Document. Leave. Payment of salaries of
Actually, E, sir. 25/10/2002. Yes. Sir.
ಅಧಿಕಾರಿಗಳ ಸಿಬ್ಬಂದಿಯ ವೇತನ ಮತ್ತು
Yes. Let they will consider within 4 weeks. Cannot be. Anyway, that you raised in your representation. That's why I asked them to consider it within 4 weeks. That you have stated. 28 ಮಂದಿ ನೇರ ನೇಮಕಾತಿ ಮಾಡಿದ ಹುದ್ದೆಗಳು 29 ಎಂಬುದಾಗಿ ಪ್ರಸ್ತಾವನೆ ಮಾಡಿ. ಆದರೆ ಕಾಯಂ ಪೌರ ನಾಮಿತ 39 ಜನ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿತ್ತು. You have stated actually. What you argued that you have stated. Yes. Regularization. That's why let them take a decision within 4 weeks. No, that cannot. That cannot be selection. Process. Once the process of selection is started on 16/1/23 at this time, so it cannot. Only thing is your grievance may be considered. Anyway, it is said to be considered by them now. Yes, sir. No, nothing else. Then the AG accept notice for respondent number 1 to 3. It is the case of the petitioners that the petitioners are working as Paura Karmikas. Please run. Or Paura Karmikas in the fourth respondent TMC on daily wages. Full stop. It is further stated in the petition that the petitioners are seeking regularization of their service with the respondent number 4. Seeking regular. Or it is the case of the petitioners that the petitioners have been appointed as Paura Karmikas, and they have been appointed, and their regulation was made in the year 1995 itself. And 1995 itself, and the respondents herein have given the benefits accrued to the petitioners herein. It is further stated in the petition that the first respondent is likely to fill up the vacant post of Paura Karmikas, accordingly formulated the rules as Karnataka municipalities within bracket recruitment of Paura Karmikas in city municipal councils, comma, town municipal councils and town panchayats, close the bracket. Again, special rules 2022. It is the grievance of the petitioner that the second respondent has issued direction to the deputy commissioners to take steps to appoint Paura Karmikas on direct appointment, direct recruitment on the basis of the letter dated 9/1/2023 in bracket annexure G to the petition. Full stop. The first respondent authorities have prepared the list of vacant posts in the state of Karnataka as per the information received by them from the respective councils and panchayats. Full stop. It is stated in the writ petition that there are 114 sanctioned posts in Hoskote Town Municipal Council, wherein 28 Paura Karmikas posts are regularized and 29 posts are vacant as per the list stated annexed at annexure H to the petition. Full stop. In the backdrop of these aspects, the third respondent herein has issued a notification to fill up 29 vacant posts in the fourth respondent CMC, and the third respondent has invited application for the 29 vacant posts as per the notification dated 16/1/2023. Full stop. It is further stated in the petition that as the petitioners were regularized in the year 1995 and the regular increments have been extended to the petitioners, and therefore, the petitioners have made a representation to the first respondent herein to consider their grievance with regard to their increments and arrears of salary, and the said representation dated 22/23 in bracket annexure N is unattended by the first respondent hearing. Second respondent. Hence, the present writ petition is filed. I have heard Sri R. Shishidhara. Let us listen. I heard Sri R. Shishidhara Lana counsel appearing for the petitioner. Sri M.S. Nagaraj Lana counsel appearing for the petitioner. Sri R. Shishidhara Lana counsel appearing for the petitioner argued that in the event if the notification dated 16/1/2023 within bracket annexure J to the petition, where the recruitment process is allowed to be done insofar as the fourth respondent CMC is concerned, the hardship will be cast to the petitions hearing who have been appointed in the year 1995 itself, accordingly sought for interference of this. Per contrast, Mr. So-and-so and AGA sought to justify the action of the respondent government, initiating recruitment process in the state of Karnataka. Having heard the Lana counsel appearing for the parties, the core question to be answered in this petition is that whether the respondent authorities notifying the remaining post for recruitment in the guise of taking into consideration the recruitment made in the year 1995 itself, as the petitioners were not accordingly paid the increments. In that view of the matter, taking into consideration, I am of the view that quashing the impure notification dated 16.1/2023, within bracket annexure J at this stage does not arise at all. However, the respondent number 2 is directed to consider 2 and 3. Respondent number 2 and 3. 2 and 3 are directed to consider the representation dated 2/2/2023, but it is given only to the Deputy Commissioner. N and N1. Yes, 2/2/2023, within bracket annexure N and N1 in accordance with law, with an outer limit of 4 weeks from the receipt of this order. This court has not expressed any opinion on the merits of the case, and it is open for the respondent authorities to consider the grievance of the petitioners in accordance with this. Contempt. That's all. Consider contempt is there. SO file is required actually. Annexure?
The date is 23. But who goes for assistant electrical?
Yes.
Created. I think not state government in not this commerce.
Yes.
This much. Next, the bill page 26, but the mode of it is deputation from KPC. They also mentioned in page 50.
Yes.
This is the bill. But there was a consultation between the state government and deputy. And but state government was my service to be spared is not KLB. But page 27 is the request of the state government. Pursuant to this, next the C. Sri HR Murali, Sahayaka Karyapalam,
KDB is better. Again, Ilva. Then you go. Go to the.
Next, the theme page 28. Order of deputation for a period of 1 year is not by my employer.
Yes.
Thereafter, I was relieved.
From BDA.
Yes.
BDA to the KADB.
Page 28. Page 28 is my order of deputation.
Correct.
Of my employer.
Yes.
Pursuant to this, next the read page 33. I have reported to the state government seeking reposting order.
Well,
I cannot go and take charge in KID unless reposting order is given by the state government. Thereafter, page 34 annexed F.
Yes.
The impugn order. I have two Milord. I have been repatriated to my parent department at KPC. Against those two posts, one is location certificate.
Yes.
There is no consultation, they are posted.
Yes.
My grievance is annexed G page 36. One post of assistant executive engineer electrical in KMDB is still vacant. But
one GK Harish.
Yes, he is promoted as not executive engineer.
Now it is vacant.
No, it is vacant. No, you have kindly take your order sheet dated 21 to 20.
According to you, you want at least the place of GK Harish.
But 21 to 2023, taking note of all these facts, but detailed on this first.
20?
21 to 2023.
Cannot dispute that with the promotion of GK Harish. As mentioned in Annexure G, there would be a vacant position in the yes.
There should be consultation between the state government and KPTC for any deputation. Consultation has taken place.
Yes, Mr. Government.
Intent on deputation.
The last. No, what is grievance is, instead of repatriating him, you can post him to the post where Mr. GK Harish was.
So that is this.
Deputation cannot.
Deputation is not supposed to be.
Under which?
Again, you say that.
Who has to answer? Yeah, in the event, what I'm saying, in the event GKR is place is vacant. Or they are reported. Yes. You can take notice and let you take. Yes, sir. Who appears R to R? Correct. See, A Chandrachud. Yes.
There is no consultation with the state government and DPTCL so far as posting of location system is concerned. I posting to what the KIDP is in accordance with consultation with the
Because earlier you were in BDA.
earlier I was in BDA.
That's why they have consulted. That's why they have consulted.
Consultation will be matter.
No. But for this background, they have consulted. Leonard A. Chandrachud, she A. Chandrachud, Lana Council, accept notice for respondent number 2. She PV Chandrasekhar accept notice for respondent number 3. Mama, when do you want to? You are the entry model there already?
There is an interim order to the effect that not to be a post.
Yes, okay. Let it be there only. System. Interim order dated 21/2/2023 shall continue till next set of date. Let us wait. 2 weeks. 2 weeks bit to 1 date. 16, sir. Oh. Just on 16. Yes. Annexure K. Issue notice. When a counsel appearing for the petitioner is permitted to serve copy of the writ petition to the panel counsel representing the respondent bank. Issue emergent notice. Who has to consider? Who has to consider your grievance? Respondent? Who appeared for the 2 and 3 actually? They are correctly 2 and 3. They have to consider. Who appears for the Manmul? Can I issue a emergent notice? Interim order no.
Examination.
That cannot be done. Maybe true. Yes. Only time. You mentioned who appears for this suspended order. I can order notice for them. Interim order at this stage. With this, your prayer is only to consider. That's all. That cannot be. No. Once the selection process has begun, that cannot be stalled. Yes, Lanadi. ಯಾರ ಪೇರ ನಾಗರಾಜಪ್ಪ ಅವರು ಮಂಡ್ಯ ಇದಕ್ಕೆ ಮನ್ಮಲ್ಗೆ ಹೂ ಅಪ್ಪಿಯಸ್ ಇಲ್ಲ ಮನ್ಮಲ್ milk producers. Leonard AG accept notice for respondent number 1. Issue emergent notice to 2 and 3. In the meanwhile, Lana counsel applying for the petition is permitted to serve panel counsel representing the respondent number 2 and 3. No. Selection process cannot be started. Nothing. No. No, nothing. You serve and you move it. Let us see. Because we don't know what is the stage today. You serve, you take hand summons also again. In addition to this, Lana counsel applying for the petitioner is permitted to take hand summons insofar as respondent number 2 and 3 is concerned. Next week only. Next. 9th, yes. List on 9th. Yes. Correct, Grievance? Shiva Kumar is. When you have transferred to the Z, please. Annexure? Now you have been transferred on? Yes.
Next year. Retirement is also 2 years. Also, premature transfer. Retirement is also 2 years.
Now you are 59 years.
Yes, 59 years and more.
That is. Jain Patel Sahib Radala. Jain Patel Sahib Radala. Now that's how I say. I think division bench. Third. Leonard AG accept notice for respondent number 1 and 2. Stay of the notification dated 24/2/2023. In bracket annexure. Annexure F till next date of hearing. Yes. What your chance? Annexure G is done. Annexure G is charged.
That's a financial. The section 4 has been excluded.
You can file a reply to the same. Let they will consider your reply.
So itself not classified.
That also you
The reason that this court and as well as state authority in the same issue has issued a notice and matters are pending. State matters are.
so according to take KTTP. ಮುಕ್ತ ನಿಧಿ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಅಲ್ಲ whether it comes within the purview of KTTP Act, let us Transparency Act. It 4E, sir. Triple E, where the procurement 4E, where the procurement is by the government departments. It is by the government or any board or bodies owns under the Karnataka Panchayat Raj Act or city municipal corporations. Established under zones. Exception to the applicability. The provisions of chapter 2. Chapter 2 is not applicable. Not the act. Chapter 2 is not applicable.
We can leave. And then you want to get this the definition of a Sahayadana. That is a financial assistant, not a different letter. Not a couple of lots.
AG accept notice for respondent 1 and 2. Issue emergent notice to respondent number 3. I said, in addition to that, the counsel applying for the petition is permitted to serve copy of the writ petition to the respondent number 3. In the meanwhile, stay off, but there's a July order. We don't know what is the stage today. Sri A. Nagarajappa, the counsel appearing for the petitioner, submitted that the respondent authorities have not taken any further steps in furtherance of the issuance of the letter dated 16/7/2022, (Annexure G to the Recruitment). In that you have to matter, all further proceedings commensurate from issuance of the letter dated 16/7/2022 in Annexure G is stayed. Yes, sir. Raghunath Joshi, sir.
Now 47, my lord, this is a simple case of seeking for mandamus for pay scale, my lord. The petitioners herein are all persons who are
1 minute, sir. 1 minute, sir. 47. ಸರಿ ಆಯ್ತಾ ಫಸ್ಟ್ ಇದೆಯಾ ಕರೆಕ್ಟ್ ಇದೆ yes who has to consider actually
my lord, sir, the second respondent, both my lord, first and second respondent, what has the second respondent board, my lord, among the persons who are regularized by a common order, for one class of people they are given a different pay scale. For us, my lord, though they are appointed under the same regularization order in persons of, kindly see page number 31 Annexure C, my lord.
Where is the order of regularization?
Page number 31 Annexure C, my lord.
31 Annexure
31 Annexure C, my lord.
1 minute. So this is the order on February.
This is the order of regulation
2nd February
70.
2011. You have been regularized.
Yes, regularized, my lord. And in fact, initially we were, all of us were regularized under the pay scale 4,800-7,225, page number 32, my lord, your lordship.
32 is there. Yes.
My lord. But what has happened, for some of the persons who are regularized in the same order, they gave higher pay scale for which we made representation. Kindly see, my lord, our representation, my lord, page number 43, Annexure E. 43, my lord. 17 ಜನ ಕಾಯಂ ನೌಕರರ ಮೂಲ ವೇತನ ಪರಿಷ್ಕರಣೆ, 17 ಜನ ನೌಕರರು ತಾಂತ್ರಿಕ ಸಹಾಯಕ ಗ್ರೇಡ್ 1 ನಲ್ಲಿ ಕಾಯಂಗೊಳಿಸಿ ಸರಿಯಷ್ಟೇ. ಈ ಹುದ್ದೆಗೆ 4,800.
According to you, you have also similarly placed.
We are similarly, and the pay scale given as to the others in the same order, we are also to be extended. That representation was made, my lord, but no action has been taken. Even association
Now,
has
what is the pay scale of the
other people, my lord? I have given. Kindly see in the one of the IFR early hearing, my lord, your lordship, IFR early hearing filed on 14/1/2022, my lord. I have produced Annexure L onwards up to I'm sorry. Annexure L onwards. In that I have produced a statement where others are drawing higher pay scale of 9,000.
What is the pay scale?
9,600 to 14,550 ಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಬೇಕೆಯವರು.
9,600
to 14,550 they have been drawing, my lord.
550.
ನಮಗೆ ಮಾತ್ರ 4,500 ಕೊಟ್ಟಿದ್ದಾರೆ. So on par with the person who I have pointed out, my lord.
Which is that another petition one? Yes, I will consider it.
Yes, my lord.
1570. 1570. Petition 1570.
This is 2017 matter, my lord. Board has never cared to file the reply statement also.
Yes, sir.
So they are trying to make a discrimination among the persons appointed along the same order. For some of them, they are extending the pay scale of 5,800, 10,500. For some, they extend 9,600. And as per the
I think for others, it was extended on 37/2014. Allah.
yes, my lord. And my lord, so far as we are concerned, we made representation that is not considered.
Yes,
And
yes. Told. Yes, sir. In these petitions, the petitioners have contended that the respondent corporation has. In fact, it is today is a day of discrimination. 1st March. Yes. It is the case of the petitioners that petitioners were regularized along with some of other employees of the respondent corporation as per the letter dated 2nd February 2011, Annexure C to the writ petition. It is further stated in the writ petition that as per the letter dated 2/2/2011, the pay scale of the petitioners along with other persons is 4,800-7275. The petitioners, first of all, it is contended by the petitioners that the respondent corporation have enhanced the original pay scale to the post of 9,600 to 14,550 as per order dated 37/2014 to the persons those who have been appointed along with the petitioners as per Annexure C to the writ petition, and being agreed by the same, petitioners have made a representation dated 25/6/2013 bracket Annexure E in WP number 26640/2017 and accordingly sought for consideration of the representation dated 25/6/2013 by the present respondent corporation. In WP number 1570/2019, the petitions in herein are similarly placed with that of the petitioners in WP number 26640/2017, and in the said petition, the petitioners have challenged the order dated 37/2014, whereby the respondent corporation has differentiate the pay scales of the petitioners and others as per Annexure D series. In view of the fact that the issue involved in these petitions are one and the same, claiming parity of the fixation of pay scale by the petitions hearing. Accordingly, these petitions were heard together and disposed of by this common order. I have heard Sri Rangnath S. Joyce Lana Council appealing for the petitioners contended that it is a clear case of discrimination made by the respondent corporation, whereby the parity of the fixation of the pay scale has not been maintained by the respondent corporation, though the petitioners and the persons who have been benefited by enhancement of the different pay scale. Higher pay scale. Have not higher pay scale is incorrect and same has to be set right. Accordingly, is sought for consideration of the representation produced at Annexure E to the writ petition. The said submission was opposed by the learner counsel appealing for the respondent. Having taken note of the factual aspects on record, it is not in dispute that the petitioners hearing were appointed on contract basis and their appointment has been regularized as per the direction issued by this court in WP number 25610 of 2009 and WA number, writ appeal number 1486 of 2010. Full stop. It is averred in the petition that the petitioners herein have been regularized in the post of technical assistant grade -1 in the pay scale of 4,800-7275 as per Annexure C to the petition. It is the grievance of the petitioner that some of the candidates who have been appointed as per Annexure C along with the petitioners herein have been paid the pay scale of 9,600-14,550 in terms of the Annexure D series in WP number 1570 of 2019. Taking into consideration the fact that the petitioners and the candidates who have benefited with the higher pay scales have been appointed simultaneously in terms of the letter dated 2nd February 2011 within bracket Annexure C in WP number 26640 of 2017. I am of the view that the respondent number 7 shall consider the representation dated 25/6/2000. It is 13, sir. 2013 within bracket Annexure at the earliest within a period of at the earliest. Full stop. However, taking into consideration the factual aspects on record that the Annexure E is of the year 2013, I am of the view that the petitioners be permitted to make one more representation within 1 week, sir.
Yes, yes.
Within 1 week from today, and on such representation is made by the petition hearing, the respondent corporations shall consider the same within 4 weeks from the receipt of such representation that
extend the consequential benefits because they are already enjoying
that made by the petitioner's hearing. Full stop. In the event if the respondent corporation finds that the petitioner's hearing have been discriminated, and accordingly the petitioner's hearing are entitled for the consequential benefits extended to the persons those who have been appointed simultaneously along with the petitioner's hearing as per Annexure C to the petition. With these observations, the petitions are disposed of. Yes.
direction. Observation. Contempt problem. Use these directions.
With these directions. Very good.
Observation contempt problem.
Yes. 48. Yes. What is challenging actually? Yes. Yes. It was absent during the recruitment process. Where is the other friend? One more opportunity. No representation on behalf of the petitioner. And a counsel appealing for the respondent number 516 is present in order to provide an opportunity to the petitioner next week only. List on 7th. Yes. Payment of gratuity. 1 minute.
Lords, serial number 49, my lords.
49.
My lords, I appear for respondents in this matter, my lord. Lord, I pray for 2 weeks' time to file my objections in this matter, please, my lord. Appear for the respondent bank.
Yes. I think this is 2019. Please file it at the earliest.
Please, my lords, 2 weeks' time, just that's it.
Lana Council appearing for the respondent number 1 and 2 dash Kavish Sharma
Yes, my lords.
submitted that respondent be permitted to file statement of objection within 2 weeks. Accepting the said submission, 2 weeks time is granted to file statement of objection. List on
Please.
15 better. 20th better. 20th. The event if they
Highly obliged.
list on
Highly
20th.
obliged. Highly
Yes.
obliged.
Yes. Government is the only part. So what your challenge is? Annexion AC. Sanskrit and Hindi. Annexion. 44. 1 minute. Twenty-one 185. Annexure H. Ayuktaru so and so. Yes. Annexure J. Yes. So they have given from 1990 onwards. For insofar as Sanskrit is concerned, 95. Yes, 1983-84, sir. Where it is stated in annexure H. 44, page 44. 83-84 alla. Insofar as Sanskrit is concerned, 1983-84. ಹಿಂದಿ ವಿಷಯಕ್ಕೆ 97, 98. ಬಟ್ 97-98 ಸಾಲಿನಿಂದ ಶಾಶ್ವತ ಅನುದಾನ ರಹಿತ ಷರತ್ತಿಗೆ ಮೇರೆಗೆ ಸೊ 97-98. ಬಟ್ it is an ancient language. It's an ancient language. That's why they are given retrospect. Huh? What is your grievance? 187. That is 28 and 96. Yes. Can it be claimed as a right?
Not be claimed as a matter of fact. Treatment, but this was considered as one. There is some additional instance.
Go on.
You are no more repetition. But
No. Yes.
there was another repetition.
225. Yes. $225. However, paragraph 7 on a close reading. Yes.
But no, that, what's the issue that I was.
240. But this was passed in the very same institution.
Same institution. The issue another and all that, say that it is not published.
How can you? This court is already has held that you cannot discriminate between the subjects. Not entitled for it. By tomorrow. Maybe true. See what this court said, while considering the case of insofar as the seniority is concerned, you given 1983-84, even for Hindi subject also it should be, this amounts to Article 14 violation. When do you Next week, Monday, Tuesday, when do you? Tuesday. Third. I will make it part-time so that it is. Third, the Lena Council appealing for the petitioner in part. In the meanwhile, Lena Council, Lena EGA seeks short accommodation to get instructions in the matter. Accordingly, list this matter on Tuesday. Na? Tuesday, na? Tuesday, very early. 2:30. Monday only. By Tuesday for further reading. Tuesday at 2:30 for further reading. 2:30 in the morning. Yes. 1 to 1 to 4. 5 is the government. Mr. So and so, Lana Council submitted that he has been instructed to appear on behalf of the respondent number 1 to 4. Registry is directed to print the name of Mr. So and so in the card list. What is the petition actually? What your challenge? Have you made representative? You can consider it. Do not. You serve copy. Do one more copy. One more. Next week, Kawana. Next week. Yes. So let's list this matter on 10 days step. 16th, very well. List this matter on 16th. Yes. But in Kalburgi or here? What's the matter? Ready, madam? Are you ready? At the request made by the Lana Council appealing for the petitioner, a list after 2 weeks. It's for promotion. Madam. Yes, well, list after 2 weeks. Yes. One minute. Setting aside the official memorandum, annexure N is challenged.
Page
120. The occupancy certificate.
There's a regulation issued by the court, action, saying that if the occupancy certificate and the developer is predicting that he will comply with the this will be this can be done.
You ready, sir? Ready. The only thing is notification dated 4/10/2018, where it is permissible by taking into consideration 2 weeks, let us say. Your filed statement. Statement is filed. Okay, then at the request made by the Lana Council appealing for the respondent board. This next week, let us say. Next week, I'll have it. Yes. 9, yes, 9:33. Ravi H. Rashmi Amma. That is after Disability Act 1995. One more amendment was made. Now the amended act is at the request made by the Lana. First, no representation on behalf of the petition. At the request made by the Lana Council appealing for the made by the Lana AGA, list after 3 weeks. This registry is directed to delete the name of Sri Ravi H.K. Kantaraja and Associates and retain the name of Srimati Rashmi Amma in the cause list. Yes. This the request made by the Learned Council appealing for the petition. 2 weeks. List after 2 weeks. Yes. Correct. Just one. Your challenge appointment of R5. Just one. On what ground that? Where is the selection list? Where is the selection list? Annex E1. Annex E1. It's a selection list. For which Dasena Halli. What is the ground on which that you challenge? Yes, sir. Just one. For which Anganwadi worker or assistant? Worker. What is the relevant qualifications? 9th standard. 9th standard. For this, sir. Where is the notification? Page numbers 17. That is 9/8/2021. On what ground that your case was not 21? You filed objection. What is the yes? What is the requisite SLC? So and so. Yes. ಅದು ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ ಇಲ್ಲ ಅಂಗನವಾಡಿ ಸಹಾಯಕಿಗೆ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಗೆ ಮೇಲ್ಗಡೆ ಇದೆ ಅಂಗನವಾಡಿ ಸಹಾಯಕಿಗೆ ಮೇಲೆ ಇದು ಅಂಗನವಾಡಿ ವರ್ಕರ್ ತರ ಓಕೆ ಸೊ ಒಂದೇ ವಿದ್ಯಾರ್ಥಿ ಉಳ್ಳವ ಹೆಚ್ಚು ಬಂದು ಕಂಡೀಷನ್ ವಾಟ್ ಇಸ್ annexure what is your percentage annexure A 76.80 that is secured by the petitioner. What about the respondent number 5? Where is that? 36. Yes, yes. The next is 476. You secured 480 marks. She secured 476 marks. Yes. Why your case was not considered? You filed the objection to the. You filed objection to the selection to the provisional list. Where is the objection? That you raised in annexure F3, page 40. F1. Yes, annexure F1 is made. What is their reply? Yes, government. It was made in 21/3/20. Not? Where is the consideration of annexure F1? Where is the endorsement issued? No instructions. See, these are all the matters has to be done. See, these are all the panchayat, within 7 days they are supposed to. On what ground you were rejected? The residence certificate was. Where is that? Where is that?
B1.
Page
B1.
17. Yes. That is yes. That's a. Annexure. Annexure B is insofar as petition is concerned. The resident of Desipalli village. So since 7 months she is residing. What is the requirement actually? Tahsildar 3 ವರ್ಷದ. But you are not complied with item number 4. Item number 4 that you are not. From 3 years you are not next. See, what are the requirement is minimum you should present in the said place for a period of 3 years. But you have since 7 months. So that's a different thing. No. That's a different. What about the respondent? Where is that? So on ground. Tell him. So you are residing in the very same place. And this is the more 24 questions. Sorry. Tell him. Please sit down. In this writ petition, petitioners have challenged the order dated 10/3/2022 within bracket annexure E1 passed by the second respondent hearing and select as appointed the fifth respondent to the post of Anganwadi worker of Dasenahalli village, KGF Taluk, Kolar district. Please run. The relevant facts for adjudication of this petition are that the respondent authorities have invited application from the eligible candidates for the appointment of the Anganwadi worker to Anganwadi worker at Dasenahalli village, KGF Taluk, as per notification dated 9/8/2021, in bracket annexure D1. Both the petitioner and the fifth respondent, along with others, have made an application seeking appointment to the said post. The respondent authorities by order dated 10/3/2022, selected the fifth respondent herein to the post of Anganwadi worker of Dasenahalli village, and being agreed by the same, the petitioner has presented this application. I have heard Sri Vasantappal and a counsel appearing for the petitioner, Sri H.C. Nataraja, the counsel for the respondent number 5, Sri M.S. Nagraj, Leonard AGA for the respondent number 1 and 2. Sri Vasantappal and a counsel appearing for the petitioner, invited the attention of the court to the notification dated 9/8/2021, and further submitted that the petitioner herein has scored 480 marks in SSLC. However, the respondent authorities have appointed the respondent number 5, who had scored 476 marks, and therefore appointment of the fifth respondent is contrary to the notification issued by contrary to the regulation made by the respondent authorities dated 23/9/2007. Accordingly, sought for interference of this court by setting aside the appointment of the fifth respondent here. Per contra, Sri H.C. Nataraj and a counsel appearing for the respondent number 5, invited the attention of the court to the documents furnished by the petitioner's hearing as per Annexure A to the petition, and submitted that the petitioner hearing was residing at the Dasenahalli village for a period of 7 months, and the rejection of the said candidature is just and proper on the ground that the petitioner is not residing in the Dasenahalli village for a period of 3 years, which is the requisite for a period of 3 years as per the notification dated 9/8/2021. Accordingly, sought to justify the appointment of the fifth respondent here. So M.S. Nagraj, AGA, submitted that as the petitioner herein as is not residing with the Dasenahalli village for a period of 3 years and has not furnished the relevant residential proof as required in the notification dated 9/8/2021, and accordingly sought to justify the action of the respondent authorities. In the light of the submission made by the Lana Council appearing for the parties, on careful examination of the notification dated 9/8/2021, wherein, the eligible candidate is required to reside in the particular village for a period of 3 years. However, taking into consideration the factual aspects that the petitioner has produced the residential certificate Annexure B, wherein it is stated that the petitioner is residing in the Dasenahalli village for a period of 7 months, and therefore the case of the petitioner cannot be considered for appointment to the post of Anganwadi worker of Dasenahalli village in terms of the notification dated 9/8/2020. However, the respondent number 5 has produced the residential certificate of the fifth respondent hearing, where the fifth respondent hearing is residing in the Dasenahalli village for a period of 24 years. In that way of the matter, I am of the view that the respondent authorities are justified in appointing the respondent number 5 to the post of Anganwadi worker of Dasenahalli village. Accordingly, I do not find any merit in the writ petition. Accordingly, the writ petition is dismissed as devoid of merits. What is this petition, Shikhar? Approve the appointment of the petition for a post of assistant India teacher by considering. Connection? N. 1 minute. Connection. Next, a copy of the proceeding 65. Yeah. Elected candidates are not good. Yes. Intermodal is the intermodal is the yes. 66. 66 is the where WP. What up? Order dated 7th February 22. Order dated 7th February. In which petition you are referring to? Order dated 7th February 20. That is annexure M in parrot. But repetitions are allowed. The selectee has to be maintainable. Yeah. Now the matter is pending before the authority. Which no. But the appellate authority say whether it is maintainable or not.
They did not approach towards the authority. In fact, he restored the
One opportunity. So, no representation on behalf of the petitioner. Then a counsel, Sri MP Srikan, appeared for the respondent in order to provide an opportunity to the petitioner. Next week, list next week. Next week. 7, sir. Yes, Mr. A few steps pursuant to the direction. What is the effect? Here, pass an order of speaking order has to be passed. That is the order passed by in annexure A. What is Annexure C, C1? Take decision. Already this court has already this court has directed to take decision. Annexure A. And also within 2 months and already available. Despite they have not taken any decision. But what happened in the contempt? Why withdraw? You consider Annexure C to C3. Already this court is in 2017 itself has directed you. 2019 also it is. Third, within 4 weeks you take decision. Third, that cannot be, but let them take decision. Third, the learner council agreed. Then what will happen? For others accept the petition. Third, the learner council appearing for the petitioner and learner Mr. So and so AGA for the respondent. CH-24 V learner council appearing for the petitioner invited the attention of the court to the order dated 4th July 2019 in WP number 52119 of 2017, within bracket Annexure A, and argued that though the direction has been issued by this court to the respondent authorities to consider the case of the petitioners for refixation of the pay scale of the petitioner. However, the respondent authorities have made a discrimination by allowing the application made by the similarly situated persons. However, the same benefit was not extended to the petitioner hearing. Accordingly, he submitted that the respondent be directed to consider the representation produced at Annexure C to the petition. But Annexure C is by the association. Where is your individual? It is Karnataka Rajya Praudashala ಮತ್ತು ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಗ್ರಂಥಪಾಲಕರ ಸಂಘ. That is a grievance of your association. Where is your claim? Next. Just let them, that is a 14. 2014, that's 8 years back. No, after the order passed by this court in Annexure A, have you approached them after Annexure A? That's why they are not considered. That they will give one more. Anyway, the order is passed by this court. Accordingly sought for interference of this court to consider the representation dated 27/1/2014 within bracket Annexure G to the Repatriation. However, the per contrast is so and so and AGA argued that, they argued justifying the action of the respondent authorities by contending that the case of the other persons have been considered on different strata, and therefore he submitted that the petitioner be permitted to make one more representation. The light of the submission made by the learner council appearing for the parties. On careful examination of the order dated 4th July 2019 in WP number 52119 of 2017, within bracket annexure A, whereby this court has directed the respondents to to take steps pursuant to the direction issued by this court in earlier writ petition in WP number 22788-89 of 2011, which has been marked as annexure B to the writ petition. However, the responding government has not considered the same. In that way, matter, on careful consideration of the representation dated 27/1/2014 within bracket annexure G, whereby the said representation has been made prior to the order passed by this court at annexure A, I am of view that the petitioner be permitted to make one more representation to the respondent authorities within 10 days from today. If such a representation is made by the petitioner hearing, the respondent authorities shall consider the same within 8 weeks from the receipt of that representation, which may be made by the petitioners in due course. With this observation, the writ petition is disposed of. After 2019 order passed by this, you should have approached them. Oral again. Represent yen kotrane madodilla oral after though you obtained an order, but you have not approached them. That is it. No, you have to guide your. Yes.
Yeah.
6/23 petition. Accommodative. 2 weeks, sir. At the request made by Sri H.V. Devaraju and a council appearing for the respondent corporation. List up to 2 weeks. And date, please. 15. Yes. Third respondent. Second respondent. Second. Who appears? It is third. And summons is third. Yes. That cannot be. That is postgraduate Chandigarh, 1998 Supreme. That is present. That is Honorable Justice, Chief Justice of India. That is referring to Karnataka. It amounts to 100% reservation. But it's a single post or single discipline. If it is a single post, and it should not be 100%. What about insofar as a single discipline?
As long as it is interchangeable, it would become single post. That is not the only. In this case, not 6 posts of officer.
Where is the notifications? You are ready, sir? You are ready. Who appears? Any other counsel apart from government advocate or sare barodilla or bere court alli irtare? So any other person? Huh? Any other person apart from Srimati Nagesh? MC Nagashri, accept notice for respondent number 2. Yes. MC Nagashri, accept notice for respondent number 2. Let us will see. You serve copy to the council appearing for the petitioner is permitted to serve copy of the writ petition to Srimati MC Nagashri, representing the respondent number 2. You serve, let him take. Maybe two.
Final selection is
Whether any interim order is passed.
What is that? Petition is
Subjective. That's correct. That's correct. You serve copy letter, please. 2 weeks for 20. Selection appointment shall be subject to final result. On the 15 days between date. List on. List on. 15th. Today itself we can serve. Yes. Yes. What is challenge actually? Annexure G. Suspension is order is. On what ground that you challenge the suspension order? What procedure has to be? That's why they are not served. Let they will consider your reply. Huh? Correct. Need not. For suspension pending inquiry, need not. That is a subjective. You appear for the inquiry. Only thing is if the suspension order is been passed by an authority having no jurisdiction, then it could be interviewed. Otherwise, it cannot. Yes. Unless it's a jurisdiction is vested with the officer is not there. Otherwise, it could be interviewed. Cannot be interfered. It's a suspension. They say that. Ilaka vicharana कायदे से अमानत की गई. Yes. Maybe. Anyway. Yes. You file reply to the same, then let them take decision. Third, Shri Arsha V. Lana counsel appearing for the petitioner. Pallava R. Lana counsel appearing for the respondent corporation. It is the case of the petitioner that the petitioner is working in the respondent corporation. First. Reply has been received. 1/8. Yes. 30/12/2000. Yes. Yes. Yes, correct. That you issued a notice why action should not be taken against you. Thereafter, pending inquiry that you have suspended him. Yes. No, that is always open. So far suspension is concerned, it's just anyway the pending inquiry, which ilaka vicharana kaide is. The petition that the respondent have issued show cause notice dated 30/12/2022 within bracket annexure D, seeking explanation from the respondent from the petitioner for the reasons for not attending the office work for a period from 23/12/2022 to 30th/12/2023. In terms of the Karnataka Civil Service in bracket conduct rules 1966. The petitioner made a reply dated 5/1/2023, annexure E to the Recruitment. It is a case of the petitioner that the petitioner was hospitalized during when from 26/12 was hospitalized on 26/12/2022 and 27/12/2022 as per annexure F. However, the respondent authorities have issued the notification dated 5/1/2023 within bracket annexure G, pending, keeping the petitioner in suspension pending inquiry by order dated 5/1/2023. Feeling good by the same, the petitioner has approached this court. See, Lana Council, she owns Arsha V. Lana Council appealing for petitioner contended that the respondent authorities have not considered the reply made by the petitioner dated 5/1/2023 within bracket annexure E, and on the very same date, the order of suspension has been passed. Accordingly, sought for interference of this. Per contra, Mr. So-and-so Pallava and the council appealing for the respondent corporation sought to justify the action of the respondent corporation. In the light of the submission made by the Lana Council appealing for the parties, it is not in dispute that the respondent corporation has issued the show cause notice dated 30/12/2022, seeking explanation from the petitioner for unauthorized absence for a period stated in the show cause notice. The petitioner has made a reply on 5/1/2023. However, taking into consideration the facts that the petitioner hearing has already been suspended pending inquiry, I'm of view that at this stage, interference with the order dated 5/1/2023 is very limited and very limited under Article 226 of the Constitution of India, and therefore I'm of view that the petitioner not made out a case for interference so far as the order dated 5/1/2023 is concerned. However, it is open for the petitioner to file reply urging all the available grounds available for him as urged in the petition before the respondent corporation. With these observations, the petition is disposed. Afternoon.
Well, it's 63.
Afternoon, I will take it up finally.
Okay.
65. Objection made by 65, not before ESIJ. Yes. E65, not before ESIJ. Okay. Because on Thursday and Friday, I have to take up RSC matters. Afternoon. As per the, especially as in the nearly 50 RSS are there. Thursday, Friday. Huh? 10 each. 10. Yes, sir. Yes, sir. Take it. I will take it up after 2:30 matters. There are two. After these 230 matters, I will take it up.
Okay.
No.
2:30 minutes. Another. Yes, sir. Yes, sir. Huh? That's all. So, Okay, I will dictate now. No, I will dictate is here. 27. Say number 27. So, not to get the dismissal order. Sorry, 27. Say, heard the Lana Council. Next week, the Lana Council looking for the partners. Shri Hanumantappa Haravi Gowda, the council appealing for the petitioner after arguing for some time, seeking leave of the court that this court be dispose of the petition with the direction to the respondent authorities to consider the representation that may be made by the petitioner. Full stop. In that way of the matter, comma, in the event if the in that way of the matter, without in that way of the matter, view that the petition be disposed of, reserving liberty to the petitioner to make representation to the respondent authorities. And if such a representation is made, within 2 weeks from today, same be considered within 4 weeks thereafter. With these observations, the petition is disposed.
Petty matters, serial number 67.
Have been directed to secure the records. Call him. According to it is served on him. Even it is served on you. Huh? No, not only the for having served the charge sheet is important. Whether charge sheet is served on you, served, then you yourself has received it. No. Even otherwise, I having you received it. You yourself has signed it. The postal agreement is signed by yourself. Yes. Then they have complied with the principles of natural justice. Yes, paper publication also. That we have taken. That is in two newspapers that you have. Anyway, today it was listed only to ascertain whether you received the charge memo or not. It is not a case for interference. No, that is a different. The only thing is that you whatever the challenge has been made, I think that is in fact is confirmed. That's why. That's a different thing. That's a different cause of it. You can approach them. The event. No, that cannot be. Direction cannot be granted. Maybe even now we can approach them also. That direction cannot be issued. You make representation in the event they have not considered as a different cause of it. Not a case for interference. Sorry, Deputation is dismissed. Not a case for interference at this stage. Yes, sir. That is always there. Here only the what your challenge is the inquiry. Only as you said that you have not received the charge sheet. I asked them to file the. That's one. No Basuras. No Basuras. No Basuras. Sorry. Yes. Then 32602 Sigata. So one sorry open so that I will add. Last one, natural justice. Principles of natural last. Yes, natural justice. Full stop. Full stop. When a counsel appearing for the petitioner, so when a counsel appearing for the respondent has produced the records along with the memo dated 3/3/2003, wherein the charge sheet issued by the respondent authorities is served through postal acknowledgement and same is accepted by the petition hearing, accepted by the delinquent employee, and therefore corrected. Dismissed. 68. ನಾವು ಧಾರವಾಡದಲ್ಲಿ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿಗೆ ಬನ್ನಿ ಅಂತ. ಸೊ ನಮ್ಮ ರೋಸ್ಟರ್ ಬಂದಾಗ ನಿಮ್ ನೆನೆಸ್ಕೊಂಡೆ ಎಲ್ಲ ನೀವ್ ಹೇಳಿದ್ರಿ ಅಂತ ಬಂದಿದ್ದೀನಿ. ಯಾವತ್ತು ತಗೋಣ ಟ್ಯೂಸ್ಡೇ ತಗೋ ಟ್ಯೂಸ್ಡೇಗೆ ಬೇರೆ ಇನ್ನೆರಡು ಇದೆಯಲ್ಲ. 1 minute ಅವತ್ತು ಅರೌಂಡ್ 3:30ಗೆ ಅಂತ ಆದ್ರೆ ತಗೊಳ್ಳೋಣ ಬೆಟರ್ ಅಲ್ಲ. ಎರಡಿದೆಯಾ? Do one thing. List on Tuesday at 3:30. So 2:30 matter to have two matters. So 3:30 gather so that it will so that statement you can serve copy and file it in the registry so that it. Yes. Yes.
Party important.
2011 matter.
Serial number 63, Miller.
63, sir. Yes.
Yes, Miller. I am the petitioner.
You are the petitions.
Yes, yes, my lord. My lord, kindly go through the order dated 17/1/2023.
17.
17/1/2023.
Shall the party, the petitioner who appears in person quashing the order for dismissing him from service with necessary direction to the first respondent to treat his letter dated as a letter of resignation with effect from such date and holding that he may not be ever admitted to any financial. Yes, sir.
My lord, I am also a practicing advocate.
Yes, sir.
With that, sensing it.
Yes.
If the respondent is agreed for it, I will go through it.
Yeah. Agreeable for a proposal for considering. No, yes, already stated that he may not be admitted to any financial benefit. Yes, sir.
Up to the date of my resignation.
Up
After the date of my resignation.
after the date of.
Yes, yes.
Not up to, after. So when was the order passed? That is.
My lord, in 99, it is passed in 99.
Which is that order? Which is that order?
Order of dismissal in page number, ink page number 61.
61, sir.
Yes, my lord.
61. That is order dated 3/10/99, sir.
3/10/99.
So that is a order of dismissal.
Dismissal.
So that may be considered instead of dismissal is a matter of resign from the.
Yes, my lord.
That's a day may be considered as a date of.
4/11/1993.
What? Which is that? Which is that? Next. So when did you file your the letter of resignation, sir?
It is in Annexure A, my lord.
Annexure A.
Ink page number 15.
15.
My lord, can I read this matter?
Yes, just I will say. ನನ್ನ ರಾಜೀನಾಮೆಯನ್ನು ಸ್ವೀಕರಿಸಲು ಏನಂತೆ that is 16/10/1993.
Yes, my lord.
Can you accept this up to 16/10/1993? Annexure A ನೋಡಿ. So for a period of 22 years he has rendered his service. That's what correct. If you look at the 17/1/23 order, I think up to 16/10/1993, whatever the benefit you will get. What the corporation say that? So what about the retire any benefits arising of?
Yes, my lord. Gratuity, provident fund, and voluntary retirement benefits.
Gratuity and whatever the benefits that as per law is. Pretty. Just pass on to me. What they are saying, sir,
Yes,
they are not to extend any benefits actually.
no benefits they have to give up to the date of my resignation.
Get instruction better, right? To advise them properly. No. Good. It in a proper way. In the event if the adverse order is passed. Maybe true. Even in RSA also concurrent findings will be interfered. In departmental inquiry, we have enough judgments. Huh? Maybe true. You advise them properly. Get instructions. Well, 15 days in. ಆಚೆ ಫೋನ್ ಮಾಡಿದ್ರೆ you will get it. ತೊಂದರೆ ಇಲ್ಲ. Because I am saying ನೋಡಿ ಅವರು ಯಾವುದೇ ಎಂದು ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಮುಂದೆ ಸಮ್ಮತಿಸಿದಲ್ಲಿ ಬ್ಯಾಂಕಿನ ಆರ್ಥಿಕ ನಿರ್ದೇಶನ ಸಮಂಜಸವಾಗಬಹುದು. They cannot say that. ಗೊತ್ತಾಯ್ತು. You ask them in a proper way. It has been except up to 16/10/1993, whatever the benefit he can get it. Otherwise, what will happen? So far as even you put it to them, better I think. Yeah, but next week ತಗೋಣ. Yeah, 13th ತಗೋಣ.
Much obliged.
13th ತಗೋಣ. ನೋಡೋಣ. Let you will get instructions. You put it them from your words, because what will happen? You
Well,
tell them. We don't know what will happen in the court.
Miller 14th, Miller.
Huh? 14th item. Yes. We tell them, see, sometimes there's resignation and so, whatever the benefit till that date, because he has rendered service for nearly more than 2 decades. Annexure A is 16/10/1993, not after. Prior to that, whatever the is entitled, releasing. That is a good. Yes, told. Pursuant to the order dated 17/1/2023, this court, pursuant to the so, the counsel appealing for the respondent seeks short accommodation to get instructions from the respondent bank. So released on Tuesday, 14th, sir.
Much
14th, 2:30 for further hearing.
Much obliged.
Yes, that is good. So that
Kindly
whatever,
take it as parted, Miller.
further hearings.
Parted.
Yes, sir. Whatever you will get till the date of the resignation, not further. He is not seeking also. Till that, to consider. Third. Memo retirement. Or your retirement. You can take back the memos. 64. Sir, yes. Yes, sir. That is counsel. If it is required, I will grant time, just so that I can hear it. You are also ready, Alice. You are also ready. Petitioner, what is challenge in this? Setting aside the appointment resolution made therein in respect of appointment of a bill collector, rejecting the application made by Annexure G is challenged.
As per Annexure G, my lord.
So you appointed on temporary basis. Correct.
You continue.
As per the resolution dated?
Yes.
Yavat, what is the resolution dated? 3-1 ಅಂತ ಇದೆ, year ಇಲ್ಲ. 3-1-2006.
Petitioner is appointed on 3/1/2006.
Annexure A is of 3-1-2006. Yes.
Petitioner was appointed.
Yes. Yes. Yes, sir. 70. Yes, sir.
ವರ್ಗದ ಇತರ ಹುದ್ದೆ ಅಂದರೆ ಕ್ರಮವಾಗಿ ವಾರ್ಡ್ ಮುಖ್ಯಮಂತ್ರಿ ಉತ್ತಮ ನಡತೆ ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿದವರು ಹಾಗೂ
I think preference shall be given to the those who have put in more than 5 years.
Next page also 19.
One minute. That is 17. Yes.
19.
Yes.
ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳಲ್ಲಿ ಸತತವಾಗಿ 5 ವರ್ಷ
Correct.
Therefore, I should have been preferred, I should have been.
For which post? For which post you are seeking? Bill collector.
Yes.
Requisite qualification is ಪದವೀಧರರು ಮತ್ತು
No. To fresh appointment again, our notify ಮಾಡ್ತಾರೆ.
but no, you must have a requisite qualification for that.
Annexure M.
Annexure?
M.
Yes.
He qualified, more than qualified.
Yes, sir. Yes, sir. ಪಾಸಿಗೆ 5 ವರ್ಷಕ್ಕೆ ಹೆಚ್ಚು ಜನ ಪಂಚಾಯತ್ ಭರ್ತಿ ನೀಡೋ ಬಗ್ಗೆ ಪರಿಚಯ ಸೂಕ್ತವು. Whether this post is by promotion or whether by directive. Who? You are working in the same place.
Now that the resolution is not annexure G.
Annexure G.
G.
Yes, sir.
ವಿಚಾರವಾಗಿ ಚರ್ಚಿಸಲಾಗಿ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಹುದ್ದೆ ಖಾಲಿ ನಿಜವಾಗಿ ಆಯ್ಕೆ ಮಾಡುತ್ತಾರೆ. ಎರಡನೇ ಓದಲಾಗಿ ಸರಿಯಾಗಿ
What is the qualification of Rudresh? Just a minute. Oh, he has been appointed. What is his qualification? M. Master of Arts. Oh, very good. Yes, sir. No, just I want to know what is the requisite qualification for this post? But for a director recruitment, they say that he should be a Paravijara. That's why I'm saying it's not the question of Rudrashappa or yourself. You have to look at from the angle of the post. For a bill collector, one who has done SLC is different from one who is having the degree. No, they say that preference.
The qualification required is only.
It's not correct. Even that circular itself is also not correct. Appears to be.
Next page 70.
17.
ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಲಭ್ಯವಾಗುವ ಕರ ವಸೂಲಿಗಾರರ ಖಾಲಿ ಹುದ್ದೆ ಪಂಚಾಯತಿ ಸಿಬ್ಬಂದಿ ವರ್ಗದ ಇನ್ನಿತರ ಹುದ್ದೆಗಳ ಕ್ರಮವಾದ ವಾಟವನ್ನು 5 ವರ್ಷಗಳ ಸೇರಿಸಿದೆ. SSLC ಉತ್ತೀರ್ಣರಾಗಿರುವಾಗ
ಇಲ್ಲಿ ಬರ್ತಲ್ಲ ಉತ್ತಮ ನಡತೆ ಹೊಂದಿರುವ ಸಿಬ್ಬಂದಿ ಅವ್ರ ರೆಸೊಲ್ಯೂಷನ್ ಅಲ್ಲಿ ಏನಾಗ್ತಾರೆ ಅಂದ್ರೆ ಸರಿಯಾಗಿ ವಾಟರ್ ಬಿಡ್ತಾ ಇರ್ಲಿಲ್ಲ. ಉತ್ತಮ ನಡತೆ ಹೊಂದಿರುವ ಸಿಬ್ಬಂದಿ ಕಾಂಡಕ್ಟ್ ಶುಡ್ ಬಿ ಗುಡ್ ಅಂತ. But even if you take it as a subjective satisfaction. That in the event, even that cannot be done, you know. Already in the resolution passed, you know, the resolution passed saying that sariyagi neer bidta irlilla uralella. No, whether it's inquiry required or not is a different thing. But it's a subjective satisfaction of. Let us. What is your case? What is your? You filed a statement of objection. To your completed degree, your master's degree. Also, they have received complaint against the petitioner. Received complaint against the petitioner. Yes. Then next page 20. What is the Suttole? Anyway, yes, put in 10 years. Yes, put in 10 years, not at this stage. Why it was not taken up at initial stage? 2012 petition. No, it is a requisite qualification for claiming regularization under Uma Devi. 10 years of it.
I am not done.
Yes, it is open for you to make an application. It is open for you to make an application. In the event, no. If they want to reconsider, they have to set aside his support.
They will not. That will not be.
Anyway, that at this juncture, interfering with the 2000, it would have been a different thing in 2012 and 13, not in 22. You know from your experience. Your experience.
Without disturbing is that will be made.
Yes, that could be. Totally. However, it is open for you to. It is open for them to approach the authority. That's it. Totally. Please say. Because 10 years is, you know very well. Totally. in this writ petition, petitioner is, yes, please, sir. Petitioner is assailing the impugned resolution dated 30/8/2012, passed by the third respondent Gram Panchayat, appointing the third respondent to the post of bill collector as per Annexure G to the writ petition. The relevant facts for adjudication of this writ petition are that it is the case of the petitioner that the petitioner was appointed as pump operator in the second respondent Gram Panchayat on 3/1/2006, and he was continuously working in the second respondent Gram Panchayat. It is further stated in the writ petition that petitioner has completed PUC course and was working with the respondent Panchayat for a considerable period. And therefore, as per the notification, as per the circular issued by the respondent government dated 4/1/2008, within bracket Annexure D, the respondent Panchayat ought to have appointed the petitioner for the post of bill collector in the respondent Panchayat. The grievance of the petitioner that though the said circular has been passed by the respondent government, the respondent Panchayat by impugned resolution appointed the third respondent herein, and being and feeling aggrieved by the same, the petition has presented this petition. I have heard Sri A. Keshava Bhatt, Lana counsel appearing for the petitioner, and Sri Nagarajappa, Lana counsel appearing for the respondent number 3, and Sri N.R. Jagadishwar for respondent number 1, and Sri Swami and Shiva Prakash K for respondent number 2. Sri A. Keshava Bhatt, Lana counsel appearing for the petitioner, invited the attention of the court to the resolution passed by the Panchayat dated 3/1/2006, as well as the circular issued by the government produced at Annexure D to the writ petition, and argued that as the petitioner was working as a waterman for more than 5 years in the respondent Panchayat, and therefore the respondent Panchayat ought to have given preference to the petitioner, while appointing to the post of bill collector. Accordingly, he sought for interference of this court. Per contra, Sri A. Nagarajappa, Lana counsel appearing for the respondent number 3, argued that the circular dated 4/1/2008, within bracket Annexure D, stipulates the objective of good conduct of such applicant, and in the backdrop of the same, taking into consideration annexure R32 dated 25/7/2012 and therefore argued and further he contended that the respondent number 3 is having a master degree holder in and coupled with knowledge in computers is the right candidate for the post of bill collector in terms of the qualification set out at annexure D to the writ petition. Accordingly, he sought for dismissal of the petition. Then a counsel appearing for the respondent, Panchayat, invited the attention of the court to the resolution passed by the Panchayat as per annexure G and argued that as the respondent number 3 is working with the respondent Panchayat for more than a decade, disturbing the respondent number 3 at this juncture would cause irreparable loss not only to the respondent number 3 but also to the respondent Gram Panchayat. And it is also argued by them that the conduct of the petition was considered in the resolution passed by the respondent Panchayat as per annexure G. Accordingly, sought for dismissal of the petition. Having heard the learned counsel appearing for the parties and taking into consideration the circular issued by the government dated 4/1/2008 within bracket annexure D, as well as the circular annexed by the respondent dated 28/6/2012 within bracket annexure R3 within bracket 3. Again 3. R3 again 3. R3 class 3. R3 class 3. Class 3. Which stipulates as follows. Para 2 of page 22, statement of objections. Page 22. Having taken note of the language employed in the aforementioned circular, as well as annexure R32 and the resolution passed by the respondent Panchayat at annexure G, I am of the view that the respondent Panchayat is justified in appointing the respondent number 3 to the post of bill collector. Yet another ground for dismissing the petition is on the ground that the requisite qualification as set out in the annexure D, that for a post of bill collector, the candidate must possess a degree and having computer knowledge. In the present case, the respondent number 3 is a postgraduate candidate and having computer knowledge. And in that we have to matter. I'm of view that the petitioner has not made out a case for interference in this petition. Accordingly, writ petition is dismissed. However, taking into consideration the fact that the petition hearing is working since 2006 with the respondent panchayat, it is open for him to approach the respondent authorities and the panchayat for appointing for any other post or any plural post of bill collectors in the said panchayat. In that way of the matter, the petition is disposed. Still.
ನಾವು ಆಮೇಲೆ ಅಡ್ವೊಕೇಟ್ಸ್